Okay, there's no one in the waiting room, so we'll get started. Are you able to hear Ms. Kell?
I am, thank you.
Okay, great. Well, this is 2020cv332085. We've got some familiar litigants here. If you all don't recognize each other, you got bad memories. But I am going to figure out who all is on the call here, so we make it clear for Ms. Kell who will be addressing what. This is, I don't know what round we're in the Phoenix versus Richardson litigation, but we're past the substance and now we're to the dollars. This is a attorney's fees dispute relating to the second lawsuit that was brought. The first lawsuit was Phoenix versus Richardson, jury trial, effectively zero recovery for Phoenix. Then we had Richardson versus Mr. Marshall, I think Mr. Ekwere, and one other. That was partially dismissed, partially resolved by way of motion for summary judgment, all of which was affirmed by our wise Court of Appeals. And now we have a dispute over whether Mr. Richardson is liable for some of the attorney's fees for the folks that he sued in what I'm calling that second lawsuit. I think procedurally that's where we are. I'm going to let the lawyers tell me that in a minute after we take roll here. And I'm just starting in the upper left-hand corner. I recognize Mr. Downs. Hello, Mr. Downs.
Hey, Judge. Good to see you again.
Good to see you. You will be presenting in part on behalf of Mr. Richardson.
That's right, Judge. I've also got co-counsel of Mr. James Johnson here with us in the bottom corner there.
I see him. We'll get to him in a minute. So we've got Mr. Downs. There's me. Mr. Pastel, you represent Mr. Marshall and Ms. Ferris. Is that right?
Correct.
All right, then Ms. Kell is our court reporter. Mr. Barr, how are you?
Good. How are you, Judge?
I'm well. You are representing Mr. Ekwere?
That's correct, Judge. Just one of the defendants.
Yep. And there's someone named Mark.
Your Honor, that's Mark Corbin. He's on the board of directors for the Phoenix.
Okay. I'm going to mute you, Mark. If there's anything you really need to say, it can be through your lawyers. You're welcome to listen and all that, but I'll be hearing from the lawyers. And if this connection somehow isn't good for you, there's a live YouTube feed as well. And we've got Mr. Johnson.
Good afternoon.
Good afternoon. Ms. Niles is my staff attorney. Mr. Gao self-identifies as my virtual summer intern. And then we've got a 678-377-4869. Who's that?
That's my landline. I'm not listening audio through my computer, it's through the landline.
Got it. We've got double Ms. Kell. Excellent. Okay. And this is now also a live YouTube feed. If there are others, whether it's Mr. Richardson or Mr. Pastel's clients or anyone else from the board who wants to be able to see and hear what we're doing, that's available at the Fulton County Court's website. There's a link to McBurney, and this is what we're doing now. So if you click on my link, this is our live feed. I'm going to start, Mr. Pastel, with you with the narrow question of, have I framed this correctly, that we're limiting the discussion to attorney's fees? You're seeking them under two different statutes, the offer of settlement under 91168, as well as the abusive or frivolous litigation 91514. And you have made arguments under both A, where it's mandatory, and B, where it is discretionary under 91514. Is that a fair summary?
That is absolutely correct.
Okay, and you filed, it feels like about 95 affidavits. I think we got a final corrected one today that subtracted $1,000 or something, but It
Right.
sounds like you've done a good job papering the file in terms of what you need to
Well.
present. And I've got those exhibits, thanks to Ms. Niles. Mr. Barr, your client is seeking attorney's fees only under 9/11/68 and not the 9/15/14. Is that correct?
That's correct, Your Honor.
Okay, got it. And I've got the figure there. And then obviously, Mr. Downs and Mr. Johnson, you're opposing recovery of those fees, and you set forth your reasons why. And I'll give both sides a chance to articulate those reasons as we go forward. Are there any procedural matters, Mr. Pastel, we need to work through before I open this up to actual presentation and argument?
I'm not aware of any, Your Honor.
Mr. Barr?
No, sir.
Okay. Mr. Downs?
Well, two quick things, Judge. One, just kind of, I was a little bit confused about why there's now two case numbers for the second case. Believe the association filed a brand new case for the same pleading. So I think there's a 2016 case number and a 2020 number. It's been reversed.
So that's not the association. That is the clerk and the statute. If enough time passes between the closure of a matter and the filing of something like attorney's fees or whatnot, the clerk's office has, I don't mean to pin it on our clerk's office, but clerk's authorities around the state have decided that it needs to be a new matter, which can be vexing if you have to pay a filing fee for that. And so here it could be vexing for both sides, because Mr. Pastel may be saying, and by the way, Richardson, you owe us the filing fee. That's a fight for the legislature or the clerk's authority, but that was not a ploy by anyone on this call to try to add to the situation. I think it's a very, very narrow set of circumstances where you can keep the old case number if enough time has passed after the file has been closed. So I'm not going to say quite by operation of law, but it is certainly the standard operating procedure for clerk's offices around the state to require a new pleading number, a new civil action file number to be applied.
All right. Well, the reason my confusion, Judge, was just that I was able to file into the old case. So anyway, I totally understand that, because I do a lot of post judgment as well. So
sure, and that's a better way to put it, is post judgment. And I need to clarify: you, in 100 years, in theory, should be able to file something in the 2016 case. But if you try to file what Mr. Pastel tried to file, they'll kick it back saying that requires a new case number. But if you were filing something that was simply entitled response to XYZ, clerk's office will take it and say, I don't know why you want to put it in 2016, but that's what you asked for, and that's where we'll put it. So it's not sealed in the sense that nothing could be filed in there. But if you tried to initiate new activity, that's when the clerk's office says that requires a new civil action number for new action.
And the only other issue, Judge, was the 9/15/14. I do believe we've already had a hearing on that issue. We had the hearing prior to, while the previous case had just concluded, and while it was up on appeal, or before it went up on appeal, Your Honor went ahead and heard argument on the 9/15/14 issue.
This would be while what I'm calling your lawsuit, the one you brought, was up on appeal. We had a 9/15/14 hearing.
That's right.
Okay.
And Mr. Clark argued that on Mr. Richardson's behalf, and everyone was in attendance at that one.
And I managed not to enter an order on that?
That's right.
Okay. Okay. Mr. Pastel nodded his head. So you agree, Mr. Pastel, that to a certain extent, argument has already been made on the 9/15/14 piece?
To the extent anybody can remember it, it's right 3.5 years ago, or close to 4 years ago. So
okay.
I'm happy. I don't have a lot of time on that one allocated, but I think Your Honor could probably use a little refresher on it.
Well, I'm glad you think that. All right, well, but
I know
think,
I could. Right.
Mr. Downs's point is well taken, that I think the emphasis should be on the 9/11/68 if we've already, was there a court reporter for that hearing? I'm already demonstrating I don't remember much about it. In other words,
It
if there's
was,
a
Judge,
takedown.
it was transcribed.
Okay, so that's all the more reason to de-emphasize the 9/15/14 because there's a record of that, and I will certainly consult that record as I work through what we need to do. That said, it could be that I end up with questions or things come up when one side says X that the other side needs to or thinks it's appropriate to get into some of the 9/15/14 factors, and that's fine. I will hear it, but I will also be mindful that waiting for me is a nice transcript of us already having discussed 9/15/14 issues in this case.
I might just ask real quick, Mr. Downs, I don't know if that was filed in the court records or if it wasn't, if you could file it in the 2020 case. I have no idea.
I don't think I ever requested it. I mean,
I never requested a transcript either, so I'm not sure it ever got transcribed.
Well, and I didn't mean to split hairs. It was taken down, but you all don't know if it was converted from takedown into a transcript.
Right. I have no recollection of it ever being. Do you, Mr. Downs?
I don't.
Barr? Yeah. I don't believe it was.
Okay. I'm now looking at the docket in the 2016 case, and I do see Mr. Downs's response in opposition to the 9/11/68 filed in March of this year. But just seeing if there is a transcript of that.
yeah, Judge, to be fair, I mean, I never requested it be transcribed and I've not seen it, but I do have a recollection of the court reporter being present and they would have a record of that.
Sure.
If she keeps it, then we can ask the court reporter if they keep stuff 3.5 years.
Well, you guys can sort it out with if you're able to dredge up who the court reporter. So there was an order. I saw it entered an order, but it was merely allowing a response fee to the response to the fee motion, not the order I was hoping for. There was a notice of filing. What would have been argued in front of Judge Arce, who is a magistrate? Well, she does like divorce proceedings.
There was, and I have it briefly in my comments, Mr. Richardson had filed a separate TRO action,
Okay.
and that's that transcript from that proceeding.
Okay, got it. Okay, yep, I do not see a transcript for that. So that would, to me, then be a reason to have folks touch on the 9/15/14 issues here. I, of course, am familiar with the history of this litigation, but I don't want to preclude anyone from getting into that, especially since there's not a transcript I can turn to directly. All right. And Mr. Johnson, I don't mean to exclude you. Are you and Mr. Downs, you've sorted out who's going to cover what, or are you representing a discrete aspect to this? And I need to check with you each time when I'm making sure each side has had a chance to say what they need to say.
Excuse me, I'm going to cross-examine any witnesses who testify about attorney's fees.
Okay,
But I'm not going to make the legal arguments. I think Mr. Downs will handle that.
great. Well, that's a clear demarcation. And Mr. Barr, you wouldn't have had anything to say about 9/15/14 before. That's not where you're coming in. You're just coming in through the offer of settlement part.
That's correct. Solely the Rule 68 offer that was made.
Okay, got it. So Mr. Pastel, why don't you get us started?
Okay, and I will give a little bit of background, but the background I'm going to give is only pertinent to these motions because I know Your Honor knows a lot about this case. But as you pointed out, the lawsuit we're in today was filed about 1 year after that first jury and injunction trial we had with Your Honor. And this lawsuit has what I'll call in essence 3 categories of claims. The first one, that the prior trial was perpetrated by fraudulent evidence. Second, that Mrs. Ferris slandered Mr. Richardson in that email response stemming from his legal counsel. And 3, that Mr. Richardson had overpaid his condominium assessments. Now, the first set of claims was disposed of in Your Honor's motion to dismiss. And so that's the subject of the frivolous litigation attorney fee motion. All the fees relate to the motion to dismiss. The second claim, defamation, was disposed of on summary judgment. And that's the subject of our offer of judgment attorney fee motion. And then Mr. Richardson had ultimately dropped his condominium assessment claim, and that's how that one got resolved.
So you're not seeking to collect any fees in connection with the withdrawal or dismissal of the overassessment claim?
No.
Okay.
So first, I want to point out that under the condominium documents, the parties conducted a settlement hearing before we got knee deep in this litigation. Right? And Mr. Richardson, through his counsel, was able to present evidence and argument to the board as to why we should settle with him with this lawsuit, before it kicks off.
And this is, I'm going to pause you for a moment just so I don't blur these things. Everything you're saying about getting in front of the council and presenting things and trying to settle, it's in connection with this second suit. It's not further back in time that we tried to reach a resolution back when it was the Phoenix suing Mr. Richardson.
No, it's not. In fact, we were supposed to have this settlement hearing conference before the lawsuit was filed, but because of some statute issues, limitations issue, Mr. Downs and I worked it out where we held the hearing after this second lawsuit was filed.
Okay.
But before my response was due. Okay. And I had asked Mr. Richardson prior to that hearing before the board to present his special damages for slander, which he wasn't able to do at that hearing. And we confirmed the results of that hearing in a correspondence from myself to Mr. Richardson, through Mr. Downs. And I'd like to now go ahead and introduce that document into evidence. That's my letter of April 13th, 2016.
So hold on one second. Let me get into that directory. I have it open here. Oh, that's not helpful. Marshall. So these would be, all right. So I now am in a folder that says, this isn't your folder, it's mine. It says plaintiff's exhibits. So what is it you're trying to introduce? Which one?
It's an April 13th, 2016 letter.
I got it. Okay. Here it is, to Mr. Downs.
Correct.
Okay. Any objection to that letter being made part of this record, Mr. Downs?
Again, I mean, not necessarily. I mean, I received the letter, but again,
It is what it is.
I believe we addressed all these issues before. So I would just, in the interest of time, just urge us not to go back all the way to the pre-litigation. But
well, case law, this is very direct on the offer of judgment motion. And there's cases out there when there's mediation before the lawsuit begins, how that's important to the decision made on the offer of judgment.
Okay, it's admitted.
Okay, so I'll go ahead and bring it up now if that's all right, Your Honor.
Bring what up?
The letter.
Oh, I'm looking at it, but if you, you are able to do the whole share screen thing?
I think so.
All right.
Let
I'm
me give it
impressed.
a
Mr.
shot here.
Pascal.
Is that
Wow.
it?
That is it.
Okay,
Nice.
all right. And again, as I'm going to, you'll see about the defamation issue here, but it's this paragraph right here, Your Honor, where I emphasize that I ask for Mr. Richardson to bring his evidence. The first part is about the assessments, but right here about any special damages relating to the defamation claim. And as I point out in the confirmation letter, they did not provide anything at the board meeting. Okay. So we didn't resolve the case. We filed our motion to dismiss, but actually before we did that, the next thing we did was research the issues and sent Mr. Richardson a 4-page, single-space, frivolous litigation letter. And I explaining why each count, including the defamation count, was frivolous. And I'd like to offer that letter into evidence. I believe it's dated May 5th, Your Honor, 2016.
I've got it. Any objection other than your previously expressed concern, which was more of a time management concern than an objection, Mr. Downs?
No objection.
It's admitted.
Okay. And then here it is again. And again, once again, before we're launching off into expensive litigation, we sent this letter to Mr. Richardson. And as you can see, Your Honor, we took the time to explain why each count was frivolous, right? Count by count, and specifically raised in the defamation count the fact that we didn't believe he had any special damages, or that the email by Ms. Ferris was anything but her opinion. Okay. As I say, we received no response to that frivolous litigation letter. We filed our motion to dismiss and your resulting order dismissing that first category of claims. Now, at this time, Your Honor, it's important to know what's going on at the condominium, right? The Phoenix is a low-density, high-rise condominium with only 62 owners there, residents. So needless to say, most people know most people there. And as Your Honor likely suspects, Mr. Marshall has his ear to the ground and he knows everyone. And the scuttlebutt was that Mr. Richardson was seeking revenge on the association and was going to run up the cost to the associations as much as possible through this litigation. He threatened to hire Ed Garland. In fact, it was even stated such in open court to Your Honor. Mr. Richardson fought every motion and ruling tooth and nail. He appealed Your Honor's summary judgment ruling all the way up to the Georgia Supreme Court. And that was despite a unanimous 3-0 appellate ruling. And then, as we kind of briefly stated earlier during this process, he even filed 2 stalking petitions for TROs against Mr. Marshall and Mr. Bunkley, both of which were dismissed after they testified. So now I'm going to get into the offer of judgment motion. Okay, as I say, it pertains to the defamation claim that Mr. Welch dropped his account with Mr. Richardson due to Peggy Ferris's email. Remember, Mr. Richardson is a financial advisor and Mark Welch was a client of his who resided at the condominium. The statute requires the award of attorney's fees, Your Honor, unless you articulate in the order that the association did not make the offer in good faith or have any good faith basis to make the offer. And actually, I mean, Mr. Marshall and Mrs. Ferris. They're the ones that made the offer. But now, as I just said, Your Honor, most people know most people at the Phoenix. So it wasn't a secret that the only resident at the Phoenix with an account with Jack Richardson was Mark Welch. And during the pending motion to dismiss, I asked Mr. Marshall to reach out to Mark Welch to determine why he dropped the account. Mr. Welch stated that it was
Objection,
because
Your
of
Honor.
poor. Mr. Welch stated.
There's an objection.
Oh, I'm sorry.
We're hearsay. He's getting into evidence what other people have had conversations about. I'm not sure it's relevant to what we're talking about, but in any event, it's hearsay and shouldn't be used as evidence towards attorney's fees or the good faith basis of those attorney's fees.
Okay. I don't disagree with you, Mr. Johnson. Mr. Pastel is making his argument, and so I'm going to give it the weight it's due. And if he's telling me this is what Mr. Welch said, and it is merely, as he's now said several times, word on the floor at the condominium. Now, I heard a lot about word on the floor at the condominium, and the jury decided what the jury decided in the first case. So word on the floor at the condominium has the weight it's due. That said, I recall, and I suspect this is where Mr. Pastel was going, I think we have an affidavit from Mr. Welch out there.
Yeah.
That'll speak for itself. And I think it does say, I did not drop my account with Mr. Richardson because of Ms. Ferris's email, and it may go on beyond that. But Mr. Johnson's point is well taken, Mr. Pastel. You can make your argument, and I don't want to prevent you from doing that. Just know that you telling me that Mr. Marshall tells you that word on the street is X is, that's not going to be why you win your motion. But I think you know that.
No, I know that. And it wasn't word on the street. This was an actual conversation that Mr. Marshall had with Mr. Welch.
Okay, but to Mr. Johnson's point, that I don't have Mr. Welch here, and I had a chance to meet Mr. Marshall, but I want you to keep going because I understand the points you're making. I don't want Mr. Johnson to think that I will take as proof the fact that Pastel says, Marshall says, Welch said. That's not where we're going here.
Thank you.
Well, the point I'm trying to make clear, Your Honor, is that prior to us making the offer of judgment, right, my clients, right, had direct knowledge, right, that it wasn't because of the defamation. Now, granted, at that time, Your Honor, I hadn't myself interviewed Mr. Welch, and I didn't have the icing on the cake, as I call it, and that's that voice message that Mr. Richardson left. Mr. Welch, that I played at the summary judgment hearing, where he ordered, right, Mr. Welch to get to his office immediately and to never send him another text like that again. Now, Mr. Richardson knew he left that voice message on Mark Welch's phone, and Mr. Richardson knew why Mark Welch pulled his account, right? But we didn't need the tape recording to make a good faith offer of no liability or damages, Your Honor, right? As I say, that's just icing on the cake. Because at the time we made the offer, we had, one, years of prior contact with Mr. Richardson to know what he was like. We had everything that came up at the first trial, right, including Your Honor's injunction order. Right? We had the pre-litigation settlement conference that I had talked about earlier here, where despite request, Mr. Richardson didn't present any defamation damages. We had our research memos and our motion to dismiss, that was reflected in our motion to dismiss, where we argued strenuously that the statements weren't slanderous, but her opinion. And that's ultimately one thing Your Honor ruled in your summary judgment ruling, and it's what the appellate court also ruled. Then we had I was able to have discussions with Mrs. Ferris, where she explained to me why she wrote what she wrote and the evidence she had to back it up, like his parking of the cars and such, as you may remember, Your Honor. we also had, Your Honor's motion to dismiss ruling, where you made this statement, or you said that the statements were likely an opinion unless Mr. Richardson could prove the statements false. And I'm just going to do a brief quote from Your Honor's order. Okay, it states, quote, "Here what defendants are deeming to be opinion is the author's assertion that plaintiff, Mr. Richardson, suffers from an erratic and scary mental health issue that requires him to take meds to control it. Such a claim on its face is capable of being proved false. Presumably, plaintiff, that's Mr. Richardson, could, if he does in fact enjoy good mental health, offer up expert opinion to that effect because defendants have not shown that plaintiff could not prove the falsity of the offending statements. Their motion to dismiss the claim of defamation and libel is denied." End quote. Your Honor, that was a very clear signal from you as to what you were going to require. Right? And then, of course, we had Mr. Welch's statement that he didn't drop his account because of Peggy's email. I'm going to go into the case law, Your Honor. As I said, attorney's fees are mandatory because we beat the spread unless you articulate in the order the lack of good faith. Good faith does not, quote, I'm going to quote a case here, demand that an offerer, that's us, necessarily possess at the time he makes an offer or demand under the statute the kind of quantum of evidence needed to support a judgment. The obligation of good faith merely insists that the offerer have some reasonable foundation on which to base an offer, end quotes. And that's Smith versus Fortner. That's the Florida appellate case. And I've filed all my appellate cases. They should be in that folder, Your Honor, that come from Florida. And of course, both sides are citing Florida case on this issue because in Richardson versus Laughlin, the Georgia appellate court adopted the Florida case law on this issue. And that's a different Richardson, right? So, right. So that's why we use it. So some reasonable foundation, that's what we're looking at. Now, nominal offers of judgment are valid. Again, all you need is some reasonable foundation to base it on. Opposing counsel is going to argue we don't have that basis. And the case law they cite directs this court to look at three factors. One, whether the offer bore a reasonable relationship to the amount of damages. Two, whether the offer represents a realistic assessment of liability. Or three, that the offerer lacked the intent to settle the case. Okay. Obviously, we nailed the first two factors. Mr. Richardson had no damages and he could not prove he enjoyed good health. Now, I want to emphasize, Your Honor, that the factors don't require us to take an unrealistic view. Merely because Mark Welch's account was worth several thousands of dollars to Jack Richardson, that doesn't mean we have to use that amount for the purposes of making an offer. That simply would have no basis in reality. If that were required, then no nominal offer would ever be valid. The reality is what we knew at the time and what Mr. Richardson knew at the time. He did not lose his account because of Peggy Ferris's email. He had no damages. And that's the reality. And the same holds true for liability of assessments.
Let me ask you a question, Mr. Pastel. Two questions. The phone call that you played of Mr. Richardson directing Mr. Welch to do certain things, did that call, if you know, occur before or after Ms. Ferris's email?
We have the date of the voice message. It was about 6 months before, 9 months before. It was in 2015.
Okay, so it was
Peggy's
before.
email, yeah.
It was before by several months.
Yeah.
Mr. Welch closed his account with Mr. Richardson after the Ferris email.
I believe that to be true, Your Honor. I'll accept that.
Hope so. If it was before, then I think we're done on that topic.
Right.
So
You know what?
here's
I
the-
never really looked that up. I just kind of assumed that that was.
Well, I'll look it up, but assuming it was after Ms. Ferris's email, what is your response to an argument that Mr. Richardson believed that Mr. Welch dropped the account because of the email? You have demonstrated by way of an affidavit that Mr. Welch says that's not so. But until Mr. Richardson reads that affidavit, he has a good faith belief because of his worldview that it was Ms. Ferris's email that prompted Mr. Welch to close the account. And it's not, subjectively he views that, and really it's not right to say he should be disabused of that notion until he's confronted with the affidavit from Mr. Welch. Then he gets that. He can choose to continue to pretend that it was the Ferris email, but in the face of that affidavit, sworn under oath, et cetera, that would be a harder argument to make. When does the affidavit come in the process?
Well, our affidavit came after the offer of judgment.
Okay.
Right.
But before it expired?
I don't know if I published it to Mr. Downs before it expired. I believe I did have it or was working on it during the pending offer out there, according to my timesheets. But
I should be able to tell in the record of the 2016 case when Mr. Downs received the affidavit, or am I going to need to hear from the two of you looking at your records when Mr. Downs got the affidavit?
Well, I'm going to go ahead and say, Your Honor, you can assume he got it after he rejected the offer by expiration of time. I'll accept that as
Okay.
the basis. And the reason I'm doing that is I want to go back to the question you just asked before that, which I'm very glad you asked, because there is no analysis here of Mr. Richardson's point of view or his good faith or bad faith in accepting or rejecting the offer. That has no basis, no place in this discussion. And I don't want Your Honor to get reversed, on taking that
Thank you.
presumption. Right. I mean, everything is directed toward the offeror. Okay. Right. Remember the three factors I just said, whether the offeror, whether our offer bore a reasonable relationship to the damages, right? Did we do that? Did we make a reasonable, realistic assessment of liability? And did we have an intent to settle the case? Right? It's all on the offeror, nothing on the offeree. Okay. So I'm very glad you asked that question. Right. Because he very well may have thought he had the greatest case in the world, right? And it doesn't matter. His reasons for rejecting the offer are completely irrelevant. So that's why I talked about the actual damages, right? If he knew, right, if Mr. Richardson doesn't want to accept reality, there's nothing we can do about that, right? Right? We did, right? And our offer matched damages, right? My point being with the amount of damages is just because he thinks he has a lot of damages doesn't mean we have to make him a big offer to make it a valid offer.
Okay.
And then the same, I want to talk about the second prong, which is the liability assessment on our end. And don't forget your comments from your order on your motion to dismiss, right? So we knew from the first trial that Mr. Richardson did not enjoy good mental health. Prior to moving to Atlanta, Your Honor, I was a partner in Florida's largest community association law firm, Becker and Polikoff. Right? And in my 30 years of practice in the community association world industry, right, I have never seen a judge enjoin a homeowner like Your Honor did. And if we're keeping it honest, keeping it 100%, we all knew, except for perhaps Mr. Richardson, that he did not enjoy good mental health. And I want to read footnote 3 of Your Honor's summary judgment ruling, because it's particularly telling on this point. Quote, in support of his assertion that Ferris's statements are untrue, plaintiff, Mr. Richardson, presents only his say-so deposition testimony that he enjoys good mental health and has never seen a mental health professional or had an evaluation completed. In this same deposition, plaintiff also proclaimed that he regularly wears a bulletproof vest in the building, recently purchased a gun for protection, and believes that several residents went to kill him. Right? Need I say more, right? Right. It was obvious that from the liability aspect for Peggy's email, that Mr. Richardson did not enjoy good mental health.
Did the footnote say, need I say more, or did
No,
you?
no, I'm sorry. That was me. That was me.
Okay.
Sorry. I wanted to kill him, end quote. Sorry, Your Honor.
Okay.
So now going on, need to say more. I just was wrapping up to my transition to the third prong, right? That leaves only whether the offer was made in good faith to resolve the case, right? And the question of whether a proposal was served in good faith, and this is a quote from a Florida appellate decision, Wagner versus Brandeberry, turns entirely on whether the offerer made it with the intent to settle the claim against the offeree should the offer be accepted. Thus, I'm continuing the quote, the issue of good faith is determined solely by the subjective motives and beliefs of the offerer, end quote. Okay, now, nothing more would have satisfied us to be done with Mr. Richardson. This case was costing the association a lot of money and was on the heels of that very expensive jury trial.
Which was a case that you brought, not Mr.
That's
Richardson.
correct.
Okay.
That's correct. And in a case that I think they'd bring again to get an injunction against Mr. Richardson. This case was costing the association a lot of money. Okay, I'm sorry. Now, I sent, Your Honor, the offer under a good faith letter. And now I want to enter that letter into evidence. It should be the one, I believe it's September. It's only the third letter in there. I only have 3.
The August 31st.
Yes. Is that it? Yes. Yes, that's correct.
Okay.
Right.
So yeah, I have 2 things from August 31st. There's an actual pleading. And then it looks like you also have the letter that you sent to Mr. Downs.
Oh, I'm sorry. Yeah, you hadn't admitted it yet. Yes, it's the letter.
Okay.
Just a letter.
All right. Any objection to that, Mr. Downs?
No, Your Honor.
All right. It's admitted.
Okay. Oops, sorry. notes. There we go. All right, so this is the letter. The offer of judgment is right underneath it, included in the letter. And I'm explaining to Mr. Richardson, the reason behind the statute is to encourage good faith proposals and settlements. And that's exactly what we're doing. And we want this case dismissed, or done with under the offer of judgment that we've got here. And I explained for the reasons in our motion to dismiss and the reasons in your order that liability, just isn't there and that it's not slanderous.
Yep.
Right. Now, I do want to emphasize, I always put this in my offers, too, on a cover letter. I want to be sure, in some ways I'm protecting Mr. Downs, that this is discussed with Mr. Richardson and the seriousness of it and what's going on, and that we want this settled. Okay, so discuss it with your client, and I'm sure it was. Your Honor, first of all, let me explain the burden, right? We don't have the burden to show any of those three prongs. Okay, the burden's entirely on Mr. Richardson. I'm merely making my preemptive argument. And there is no evidence that our offer wasn't made in good faith. Right? Your Honor, in fact, this is not a case where the defendant simply threw out a nominal offer of judgment, hoping it would bear fruit. Right? We knew at the time of making it, the offer was justified, fair, and in good faith to end the dispute. Right? So now I have just a little bit on the frivolous litigation one. I want to say that, while that provides some discretion to your Honor, at least under the one prong, right? I'll argue in this context of this case, it demands attorney's fees. This, the claim that we're talking about on the motion to dismiss, that first category of claims, encompassed fraud and conspiracy. I mean, Your Honor, it was nothing more than sour grapes over the first trial. And case law is abundantly clear, and was at the time they filed the lawsuit, that that's not the way you go about addressing your grievances, by just filing a new lawsuit like that. And that's exactly what Your Honor found in the motion to dismiss and what the appellate court ruled on. Now, I'm not sitting here, Your Honor, arguing that every successful motion to dismiss warrants frivolous attorney's fees. But this motion in this context does. In fact, in Omni Builders Risk versus Bennett, the court stated, quote, no evidence shows any factual merit in a party's claim for fraud, a trial court erred by not awarding attorney's fees to the opposing side under OCGA 915.14. With the intentional infliction of emotional distress claim, Your Honor, we all know the high threshold needed to assert such a claim. And Your Honor found that Mr. Richardson, quote, cannot, based on his contentions, make out a case for intentional infliction of emotional distress, end quote. In other words, Your Honor, even giving Mr. Richardson the benefit of a broad reading and liberal reading of his contentions, he came nowhere close to an intentional infliction of emotional distress. And again, the appellate court pointed that out. Simply nothing in Your Honor's orders dismissing these claims indicates that there was any legitimate dispute or basis for filing this first category of claims. They were simply brought out of spite, and that's why they warrant attorney's fees under 915.14. Okay. Now, I need to, I guess, unless you want to hear argument from Mr. Barr first, I'd like to introduce my two affidavits and then testify in place if you want to do that now or later. I leave it up to your honor.
I guess, why don't we wrap up your presentation and then we'll turn to Mr. Barr.
Okay.
And because you went first, he may have less to say in terms of some of the legal argumentation, which is fine. But he'll have his own set of facts for his attorney's fees. So why don't we shift to your fees?
So at this point, I'd like to go introduce the two affidavits that were the latest. I mean, they've been the same ones filed for a long period of time, but for some reason, my computer wasn't necessarily putting the right labels on the PDFs. So I have one for frivolous litigation in the amount of $27,324.23. That should be titled the 9/15/14 affidavit. And then the other is titled the 9/11/68 affidavit that was originally for $47,000. I did agree with Mr. Downs on the ending point, so I took out the $1,300. And so now it's for $46,910.87. And I'd like to offer both those into evidence.
Okay, Mr. Johnson, subject to you cross-examining Mr. Pastel about the records that support those affidavits, do you have any objection to the affidavits being admitted?
I don't have any objection to the affidavits. I may have an objection to the actual statements of account attached to the affidavit, but I will need to cross-examine before we can flesh out the argument as to whether that's hearsay or whether he has personal knowledge of that.
Got it. Okay, so I'll admit the affidavits. I'll provisionally admit the attachments there too. And then, Mr. Pastel, you can state what you want to state as an officer of the court in support of the fees. And then I'm going to allow Mr. Johnson to ask you questions about the records that you are tendering.
Okay. All right, Your Honor. So I'll stand in place and give a little bit of resume about myself. I've been an attorney for 30 years. I started off in South Florida, became a partner at the law firm of Becker and Polikoff. As I said at the time, that was a large law firm, 100+ attorneys. I understand that's not quite as large as it used to be back in those days. It was, at the time while I was there, Florida's largest community association law firm. We had over 4,500 associations. My wife and I then decided to move up here to Atlanta to raise our family. I became a founding partner at the law firm of Winter Capriola Zenner. At both locations, I've been an active member of our trade industry, Your Honor, called Community Association Institute, and I've given talks at both and lectures at both. Our law firm has over 700 associations we represent. I head up the Community Association litigation area. My rates are customary, fair, and reasonable. In fact, these are the retainer rates that we use with our clients in the community association industry. And
Mr. Johnson, do you have any dispute with the reasonableness of the hourly rates, or is your concern, if you have one, about the compilation of the hours that Mr. Pastel worked?
A little bit of both. I don't have any problem with $270 an hour. I believe that that's a reasonable rate. That's not the rate he charged. As I'll show you in my cross-examination, he charged $270 to one set of clients and another $155 to somebody else. So he actually has a blended rate of $455 an hour, which is definitely unreasonable.
Well, we'll get there. So
Sure.
What Mr. Pastel is saying is his rate, we don't need to hear a whole lot more about that. If it was in fact 270 or lower, you aren't challenging the reasonableness of that.
If his testimony is that his rate that he's accounting for here is $270 an hour, that is a reasonable rate. Yes, sir.
Got it.
okay. And just so you're, well, actually, I'm going to get to that, what he raised in just a moment. Actually, no, I got one more thing I want to make sure I get in. We use the Orion timekeeping system It is an a software system where I always have it up on my screen. You can show the calendar of your billables to date, for the month and that kind of stuff. And then you have another little box where you can enter individual time. Right? I enter my own time personally, right? I type it in electronically. There is no paper document of my time anywhere. I make it a practice to enter my time, usually as I'm finish the project, but definitely before I leave the day. I do not like the situation where, people wait to the end of the month and enter their time. Right? Now, I'm the lead on this matter. Miss Harrison, Your Honor may remember, right? She got a lot of entries and she worked on this case also. She's had a child and has retired from the practice, right? I oversee her, right? I not only oversee her in this case, I sort of was her mentor in the office and always insisted that she do her time entries timely and correctly, right? And she does hers the same way as mine on the screen at the time. At the end of each month, I'm given the printout, a pre-bill we call it, Your Honor, before it goes to the client, and I review it and make sure the time entries are correct and proper. So now I'm going to address the comment that Mr. Johnson made that there are kind of like two sets of statements of account under each affidavit. And that's because we represented through the insurance company, Mr. Marshall, on the defense of Mr. Marshall. Now, they got in late in the game, so for much of the frivolous litigation affidavit on the motion to dismiss, it's mostly our law firm's entry, but then there is also some that we billed to the association. Now, I needed to allocate time depending upon what I'm working on. Is this something I bill to the association? Is it something I bill to the insurance company? Or is it something that I need to bill to both? Okay. Obviously, if I'm working on just Peggy Ferris, it's to the association. If I'm working on the assessment case portion, it's to the association, right? There's a lot of times where I'm working on both, or Miss Lindsay's working on both, right? And in that case, we would split our time and bill it to both. So let me give an example. So say I worked 2 hours on a matter that I felt addressed both issues, right? I would bill 1 hour under the association, 1 hour under the insurance company's matter, because they're at different rates, right? And then they'd have identical entries. So I know what I was doing, okay? And I hope, Mr. Johnson, that may not have been clear from the affidavits, but that's why it's not a doubling up. It wasn't double billing of 1 hour to get the $430. Rather, it was 2 hours, 1 hour to one, 1 hour to the other. There are a couple of times where Miss Lindsay and I attended the same function. I know, for example, in the deposition of Mr. Richardson, right, we both attended it. I billed my time under one matter and she billed her time under the other matter. So that's one where it wasn't, we didn't each split it that way. We just did one, the other, one. So I hope that explains that. As I said, I do agree with the response motion of the cutoff date for the 9/11/68. So in my affidavit this morning, I hope I marked clearly enough on those the entries that would come off, and that was $1,340. I think, Your Honor, this may be a good time to point out that even after Your Honor entered the final judgment, the association still incurred a lot of attorney's fees. right, that aren't reflected in these affidavits, in 9/11/68. I mean, we had all the legal work on the appeal to the Georgia Appellate Court. We had all the legal work on the attempted appeal to the Georgia Supreme Court. And then we have all the work here on this motion for attorney's fees, drafting it and attending it and preparing. So I just want to make sure the amount sought is nowhere near the full amount to reimburse my client by any means.
Okay. Do you have anything more you want to say about the affidavits?
I have just a couple more points. Yes, I know they complain about the discovery order in their response. I don't know if you recall, Your Honor, and I'll try to refresh your memory. Mr. Richardson's assessments, he was trying to get produced all of the owner's ledger's accounts.
Right.
Right. And I was boxed in by the Federal Fair Debt Collection Practices Act, as that would be a blatant violation of it. So I just want to point out, ultimately, Your Honor accepted the proposed order that I submitted, and had that protective language in there that I was producing under the court order, and it wasn't to be deemed a violation of any state or federal law. They also challenge a couple entries about mental health research. Your Honor probably recalls Mr. Richardson had written a very long manifesto, and in that he stated that there's likely to be a shootout, like at, quote, OK Corral, end quote. Right? We had legitimate reasons to be concerned, and in fact, Your Honor ordered the deposition of Mr. Richardson to take place in your, off one of your conference rooms right behind where you're sitting now. I know they criticized us in their response for not moving for summary judgment immediately following the motion to dismiss if everything was so clear. Two quick points on that. One, every time that happens where somebody moves for summary judgment right out of the box before discovery, the other side always files a motion arguing they want their 6 months of discovery, and it's always granted. So that becomes a waste of time. And also, remember, in your motion to dismiss, Your Honor essentially stated you wanted discovery on Mr. Richardson's mental health, right? That was the whole purpose. So it really wasn't practical to do the summary judgment right out of the box. Two more points. One is they criticize an entry RJC for 1.6 hours, $432. RJC is Richard Capriola, and Your Honor may recall him from the first jury trial. He's a partner of mine. And I don't think it's unreasonable during a litigation matter like this to ask another partner to spend a couple of hours to review the litigation strategy. Finally, we're criticized for spending a lot of time on the summary judgment motion. My strategy for summary judgment is this. I only do them if I stand a very substantial likelihood of winning. Otherwise, I'm just wasting the client's money, right? And that's not what anybody wants to do. But if I'm going to win, I'm going to win. And we do a very thorough job, right? And that saves all the money that would have been spent on a trial had we just rushed through it and not prevailed. And that would have been a heck of a lot more money than we're complaining about. So that's why we really roll up our sleeves on it. And with that, I'm finished, Your Honor.
All right, Mr. Johnson, you have questions for Mr. Pastel?
Yes, sir. Good afternoon, Mr. Pastel. I'm James Johnson. I wasn't involved in the underlying cases. I want to revisit something you said earlier, and I just want to make sure that I'm clear on this. You had in your possession an affidavit from Mr. Welch that you consider to be key and unimpeachable evidence that there was no defamation here. And yet you waited to give Mr. Downs that affidavit only after the expiration of the 30-day 9/11/68 period. Is that correct?
Let me put it this way. I knew about the information. I'm not sure if the affidavit, I'd have to look at the date. Well, here, I have the affidavit here, just a second. Yeah, the affidavit is signed September 23rd. So I had the affidavit during the pending time period that it was there.
And you didn't give it to Mr. Downs.
They said, I don't recall when I give it to him, but I don't believe I did give it to him prior.
And there's no, you'd agree with me, there's no time entries in your statements of account where you called Mr. Downs and say, I have clear and unimpeachable evidence that you will lose. Here it is. Please dismiss your case.
Well, that's not true. I mean, ever since the beginning of this case, we were telling him that we had it cleared research, it was opinion, that he never showed us any special damages. The other part is, don't forget my time entries, and I know I provided you a supplemental, but my time entries on these affidavits only starts after the expiration, so October. But I don't believe, if your point is, there's no time entry where I called Mr. Downs and said, you know, aha, you know, Mr. Welch says you're full of it. You know, no.
Okay. And you have provided me with those time entries from July and August, so we can talk about those if we need to, but I'll show you later that you in fact did not have any conversation like that.
And I'm not disputing that. So you
Okay.
don't need that.
You've been practicing law for 30 years.
It will be in October.
You don't hold yourself out to the public as a First Amendment lawyer or a defamation specialist, do you?
No.
Okay.
No.
Nothing on your website says that you handle First Amendment or defamation disputes.
I'm trying to think. There may have been times in my explanation where I talked about defamation. You know, it changes over time, but no, I don't. I'm a community association specialist. We do get slander and defamation claims, you know, routinely. I can't say how many I've handled, but 5 or so over my 30 years where you dive into it in depth.
A few days after the court dismissed the majority of Mr. Richardson's claims, but left alive his defamation claim, you made your 9/11/68 offer for $100, right?
Yeah, I mean, whatever the dates are, it's not long afterwards.
Sure. And the $100 offer was meant to signal that you didn't think very much of that defamation claim, wasn't it?
Kind of like our first 2 letters to Mr. Richardson and the cover letter to the offer. All 3 letters stated that.
Well, the cover letter of the offer just says, we don't think your claim has merit. It's got no explanation as to why he will lose legally. You'd agree with me on that?
It does incorporate the motion to dismiss.
Well, you lost the motion to dismiss on the defamation ground.
We lost it for the reasons I quoted from the honor.
Okay. And in that letter, you said it was doubtful that the claim would survive. You didn't say this is a dead loser will and you know it.
I'm glad he didn't put that in the letter.
The $100 offer, the $100 just came off the top of your head, didn't it?
No, that's what I've worked out over the years to be a nominal offer. I try to look at what the case law says, but I mean, I think I've seen case law decisions all the way from $1 to definitely $100 calling them nominal offer. So I try to stick on the higher end of it.
Okay, you didn't, aside from what you've seen in cases, you didn't do any sort of calculation in this case to arrive at that $100 number, did you?
That is because there's no question this is a nominal offer.
Okay.
Right? I've never had that, right? Nor am I now.
You
Right,
didn't
so
do
there-
any, I'm sorry, I didn't mean to interrupt you.
I was just going to say, so there is not a calculation to be done.
Well,
And you didn't.
just so we don't have to go too far in this, the calculation you made, Mr. Pastel, was that you didn't think Mr. Richardson was going to win, but it was going to be expensive to prove that. And so here's your nominal offer. So there was some math done, but to Mr. Johnson's point, the math didn't point you to exactly $100. That is your symbol, your sign that here's your nominal offer, because you're not going to get anything other than pay your lawyer a lot of money if you keep fighting this.
Yeah, maybe I should be a little bit more clear. The legal assessment was you're not going to prevail, right? There was no math of, damages, and then we think there's 50-50 chance or that kind of stuff, because 50-50 of zero is still zero. And, so it's a nominal offer in that respect.
Now, just to finish that point, you didn't do any sort of analysis of the cost of defense of this lawsuit before you issued that $100 offer of settlement, did you?
My hesitation is I believe I was doing reports I may have been doing some reports to the insurance company. And at the end of those, they asked for like a budget. So there may have been something there, but I will tell you, it was not part of my thought process. My thought process was this needs to be settled, right? There's no merit to it. Here's the offer. Let's get it over with.
On that point, you would agree with me that if we were to look at your statement of account, you regularly bill for meetings and communications you have with your clients, don't you?
Yes.
And you would agree with me in this case that there is not one single time entry for communication with your clients about the offer of settlement.
I don't know. I'll take your word for it.
Okay, and that's because you didn't actually sit down with them and talk to them about how to calculate a number to give as an offer of settlement.
I did not sit down and talk with them about a number to give. I did talk to them about the offer of judgment, and I know I even circulated it with Mr. Barr because it was a joint offer.
Do I understand you just didn't bill for that? It's not reflected in your time entries?
Let's put it this way. It's probably, the time is probably billed in there. It may not be stated as such in the entry, or encompassed. There was probably other issues going on there, and it may, so.
So it's fair to say that when I'm looking at your time entries, what you write down for a time entry might not be completely accurate as what you actually did. Is that what I hear you saying?
No, although, there's no, what am I supposed to do? Put the entire transcript of the conversation with the client in there? I mean, so there's only so much, it's an art as to how much you put in a time entry.
There's a lot of time entries about a bar complaint against Mr. Downs. There's a lot of time entries about WSB news reports. But the one time entry we'd be looking for here, conversation with your client about this offer of settlement, it's not there, right?
If you say so.
Okay. Who was going to pay the $100 if Mr. Richardson accepted the offer of settlement?
Quite frankly, I would have been happy to pay for it, but I don't know if Mr. Barr and I hadn't discussed it. I probably would have tried to push it off on the insurance company, but it would have been paid.
But you don't know, you didn't reach an agreement with anybody about who was actually going to pay it, did you?
I know I reached an agreement with myself that I would pay it, the firm would pay it if we had to get it done.
Okay. We can look at the entries if we need to. Would you agree with me, and hopefully we can save some time, that nowhere in your July or August 2016 invoices are there any time entries related to the analysis of Mr. Richardson's claim for defamation?
I'm not exactly sure of the timing. My hesitation is I believe the judge asked for draft orders. for the motion to dismiss. I don't know if that's in there. In other words, it may have been part of something what I discussed, but if you're asking, is there an entry that reads, analysis of liability of defamation for purposes of making an offer of judgment, I doubt if you'll see an entry like that.
Okay, thank you. I'm going to see if I can share my screen and pull up your 9/11/68 affidavit. Give me 1 second. All right, can you see that?
Well, I have it in front of me too.
Okay.
On a separate piece of paper.
Now, the offer of settlement expired on October 5th, 2016, correct?
I'm sorry, I'm looking back to see what date it was. Yeah. Mr. Downs and I agreed it'd be October 5th.
Okay. And you indicated in your direct testimony that you didn't file a motion for summary judgment immediately because generally the judges will give 6 months, and you thought it would be a waste of time to file something immediately, right?
That's correct.
But you started working on it the day that Mr. Downs rejected your offer, didn't you?
Yes.
Okay.
Yes.
So-
There's not a lot of work on it, but there's some fundamentals we want to make sure we get right during the discovery process as we move through it to make sure we're correctly positioned to have the best summary judgment motion.
And is it fair to say that you held off on doing any substantive work or research on Mr. Richardson's claims until that 30-day period expired?
I don't know. I mean, I wouldn't surprise me, but I don't know.
Okay. And again, we can go back at your older invoices if we need to, but after the expiration of the 9/11/68 offer is the first time in your invoices that we actually see you researching the merits of Mr. Richardson's defamation claim. Isn't that right?
No, I mean, there's a whole mess of it in the 9/15/14. I mean,
Okay.
that's where probably half of that is dedicated to the defamation claim.
Well, we can
The
walk
other
through,
half is the procedural aspect of whether he should have filed a second lawsuit or not.
okay, well, let me walk through a few of these and then I'll ask you a question. There's a
I beg
time
pardon?
entry on 10/11, research specific examples of categories of defamation per se. Do you see that?
Yeah.
The next day, research issue related to discovery of evidence of Richardson's character. Do you see that?
Mhm.
Then I'm going to go down to your insurance billing.
Are you, Mr. Johnson, which affidavit are you looking at?
This is his 9/11/68 affidavit. So it's the time after October 5th, 2016. And the way that it's broken down is that he's got one statement of account that he billed to the association and then a separate statement of account that he apparently billed to the insurance company.
Okay, I'm looking at the billing records for the 9/15/14, at least as Mr. Pastel labeled it, and it's the same thing. I was looking for entries that predated the expiration of the offer of settlement that talk about defamation, and it may just be that the affidavits are mislabeled, but the one I'm looking at that is labeled 9/15/14, the bills don't start till October 5th.
On the 9/15/14 or the,
So the affidavit that he submitted today, which is a rehash of an older one, I've got the first screen on, or first page on the screen. This is what I understood to be his 9/11/68 affidavit, and it's titled that.
right, and correct, Your Honor. See, you can see down on the bottom, there's that revised number. Bring it
I see
there.
that, but I'm looking at the affidavit that,
Well, the 9/15/14 affidavit has different time entries And that was all related earlier in the case to the motion to dismiss.
Right. It just must have the wrong, maybe it's in my folder that it has the wrong label. Let me try this one.
Look at the ones that start with the number like 9/11/68 or 9/15/14.
I can only look at what I have in my folder here.
Okay,
And one says Ray 9/15/14, one says Ray 9/11/68. They've got the
Yeah,
same,
those-
they're the same thing. So I have to,
yeah. I noticed that's what happened on my labeling that I mentioned, so.
yeah,
That
I don't
could
think
add-
I have the billing records that you associate with the 9/15/14, because these three files, these three affidavits that have different titles and purport to relate to different statutes have the same billing records, all of which start on October 5th. And I'm taking you off topic, Mr. Johnson, I apologize, but I was being curious, wanting to see what kind of entries would have predated the motion to dismiss that would talk about defamation. And I'm unable to see that because I don't have that information in front of me.
Why don't I do this? I'll move off this exhibit for now and go to what you're looking for. And I can
Okay.
ask them those questions.
Great.
Bear with me 1 second.
So you're switching now to the affidavit that purports to relate to the 9/15/14 motion.
Yes, sir.
Great.
Okay. Do you see this on the screen? And Judge, you see it's
July.
July, but it's the way that it's presented, which I obviously have a problem with. It's July, then it goes to May, then it goes to June, then it goes to April. It's kind of all over the place.
Yeah. Okay.
But these are the pre-motion order on motion to dismiss time entries.
Yes, now, those are the ones to the insurance company, and then if you go back another page, the bulk of them, oh, I think I know what happened here, is they kind of ran, I may not have separated them as clearly as I did on the other one. So here it is, John. The first page, if we go back to the first page, right, is the insurance one only. Yes, because you can see the rate of $150. Then when you, after that point, the reason it starts back in March is now we're on to the law firm ones. The insurance company didn't pick up until after we had filed the motion to dismiss. And so they only got the response parts included. Okay, so if you would be kind enough to turn to the next page. There you go, where it starts exhibit number 2 down there. This is where with our law firm's billings, and you can see the slightly higher rates. And that's from when we first got notification from Mr. Richardson about the lawsuit and our entries at that point.
All right, so let me start you here. So we're looking at exhibit 2, which is the time that shows your work on the motion to dismiss, right?
Correct.
Okay.
Well,
So-
and pre-litigation stuff too. Well,
Okay.
Yeah.
So question number 1, under 9/15/14, you are seeking the entirety of your attorney's fees that you spent working on the motion to dismiss, correct?
I'm sorry, I know I went through time entries and took things out, at least for the 9/11/68, and I can't remember if I did for this one or not. But I think for the most part, your statement sounds correct.
Okay. And to be clear, what we're looking at are not the invoices that actually went out to any of your clients. This is just some statement that you generated, right?
Yes, the Orion system, it's all paperless and electronically. We send the bills electronically, virtually too.
How is this different from what we run into on the medical side, where the bill that goes to the patient says it costs $52,000 to remove your gallbladder, but don't worry, we massage it, insurance does this, and out of pocket for the client, the person whose gallbladder is now gone, is $12,000. That ought to be the number we're talking about. These numbers you're telling me are not necessarily numbers that the association was confronted with.
No, that's incorrect, Your Honor.
Okay.
You see the column called billed amount?
Yeah.
Right. That's the amount I ultimately billed the client. And that went to the client, and I guarantee you the client paid it. Right.
Okay.
Right.
And I'm seeing that original amount and bill amount are the same in
They almost always are. And probably in this case, they always are, Your Honor. But I will tell you on occasion, sometimes I will put no charge, in which case the billed amount will be zero if for some reason I wanted to treat a client or whatever. So that's why you have the two columns.
But what you're seeking would always be the sum of the bill amounts, not the sum of the original amounts.
Absolutely correct.
Okay. I want to go back in case Mr. Johnson wasn't going to. He asked you if you are seeking under 9-15-14 to collect for all the work done on the motion to dismiss. And then you didn't really answer it. You said some things, but it wasn't a yes or a no. What is the answer to that question?
Give me a second. No, it does not appear that I am seeking all the time spent on the motion to dismiss. There is not, I called out, it appears like I called out the entries that would have related to the defamation research, and doing that stuff. And for, it also appears like I took that out for the assessment claim he was making. So when I was doing research on just the assessment or research on the defamation claim, those are not part of the 9-15-14 motion. And so they're not, we won't see those entries in here.
Because those were not parts of the motion to dismiss where you prevailed.
Correct. Yeah. So I'm not asking for the 9-15-14.
Okay.
Judge, I've got some cross-examination on that, but I will note that that puts us in an unfair box because he seems to be saying, well, Johnson, you can't say that I did all my defamation research after the 9/11/68 because clearly they're in my invoices before, but I didn't show you those invoices. I showed you the invoices where I took all that out. So the only evidence we have in front of the court is this document, whatever it is. And it's, as the court can see, all of the time entries about research and doing stuff are all block billed. So you can't, I don't think there's any basis for him to say he took out discrete line items about defamation because all of the entries are block billed with multiple time entries. So I'm looking at one, for instance, let's look at this 4/4/2016, 8 hours of research by Mr. Pastel. Research issues of grounds to set aside the judgment, fraud, conspiracy, abusive litigation, intentional infliction of emotional distress, and defamation. So clearly in that block billed entry, he's seeking some fees for defamation, which he lost on the motion to dismiss level.
Okay.
And Mr. Pastel, my question to you is, based on the documents that you've presented to the court today, the exhibit attached, the statement of account attached to your 9/15/14 affidavit, There are no individual line items about defamation at all, are there?
No, those would have been removed.
Okay,
Right,
so
because that would be just like you're making an issue out of that entry where, and believe me, I did, Your Honor, spend a lot of time researching how he should have brought that claim on that first one, because that's the best way to prevail on a motion to dismiss, is to explain the proper way. And you're criticizing me for also including some defamation work in there. So, yeah, no, I tried to make sure they're not in here, it looks like, and it looks like for the most part, I think I did a pretty good job of doing that. Now, are you saying some of that entry should be allocated away because it includes defamation? Okay,
you understand that that is actually the law. You must segregate out the time entries that relate to items you lost on versus time entries that you succeeded on. And you don't get your fees for defending a claim that you lost on a motion to dismiss, right?
that's right. And that's why I segregated the claims in my affidavit that you're saying you're unfair advantage on. And that entry there, as I kind of emphasized, I mean, that's where my time was spent, was on those set of first claims.
All right, well, let me ask you a couple questions and I'll move on. Let's look at your April 12, 2016 time entry. And it reads, continue to finalize draft of motion to dismiss, forward to co-counsel, prepare memo regarding good faith dispute meeting, attend and host same, 7.3 hours. Question number one, that's a block billed entry, and neither the court nor you nor I can tell how much time you spent on each of those discrete tasks, correct?
I think correct is a good answer.
Okay, then
Correct.
when
In
you
fact,
say
just
continue to
agreeing with you.
finalize draft of motion to dismiss, you can't pull out of that unidentified time the time that you spent drafting the portion of the motion to dismiss that related to defamation, can you?
No,
Okay.
no, I didn't, let's be fair here, Mr. Johnson. At the time I'm putting in those entries, right? I don't know what I'm going to prevail on. I'm not thinking about 9/15/14, 9/11/68, what I'm going to bill on. In order to meet your standard, these entries, I'd be spending about a third of my day doing time entries. right?
Well, I want to cut it short. I don't disagree with either of you, but if the law is, it needs to be segregatable, it's a risk that practitioners take that, for example, the April 12th entry maybe, I'm not ruling now, be one that I can't count, or I'll be coming up with some rule of thumb to say, here's the percentage. The motion to dismiss was 55% successful if 5 counts got dismissed. So I need to discount anything that doesn't segregate out the counts for which you didn't prevail, Mr. Pastel, by 44%. But it's further complicated in looking at the April 12th entry by the fact that I don't know how much of the full day's work you put in was dedicated to finalizing the draft motion to dismiss. So I don't disagree with Mr. Johnson, and the law may support him about how I have to handle block bill entries in this context. I don't disagree with you. There are reasons why people come to work in the public sector, because you don't have to deal with Orion and all that kind of stuff. So you're sort of in a trick box. I think your entry for April 12th is probably pretty standard for a whole lot of busy practitioners because you're not thinking down the road 9/15/14 or 9/11/68. You're thinking, I don't want to clog my day with dealing with Orion, but here we are. And it's not possible, given what you've presented, for me to dissect that to say, here's the piece that should come out, absent a kind of crude ratio like I came up with. Well, 44% of whatever part of that day happened to be the motion to dismiss ought to come out. So I share all that with you, meaning I'll be wrestling with it. We don't need to have a back and forth between the two of you on that. The law says what the law says.
Okay.
And so last question on this document, Mr. Pastel, your testimony is that there is some different document out there that has additional time entries specific to the defamation claim?
There is, I don't think we call it documents, there's data, right? Our firm would have data in the server, right? If there was a printed version of the bill to Phoenix, there would be other entries on there that were removed because they don't pertain to this motion. But as I say, we're pretty much a paperless law firm.
But
There's not-
don't get hung up on the paper versus digital, because you could turn it into paper. It
Okay.
sounds like you could run a report for the month of April 2016, work that you and Ms. Hillis did on behalf of client 001111 in connection with Mr. Richardson. And what you're saying, Mr. Pastel, is that there'd be more entries than I see here.
Absolutely.
Because you removed some because you concluded that they did not pertain to the 9/15/14 motion. It's legitimate work you did for the Phoenix in connection with this litigation, but maybe the entry was defamation, and then that ought not to be in here.
Correct.
But you could generate that record
Yes.
if Mr. Johnson wanted to see it, provided it didn't have any client-sensitive info in there.
That's correct.
Okay.
Thank you. I'm going to now move back to your 9/11/68 affidavit. And I'm going to go to the, there we go, okay. I'm just going to point out a few time entries. So you say that you spent a lot of time up front in the case analyzing the defamation claim. You would agree with me, and I can go through this with you if I need to, you would agree with me that there is a substantial amount of time reviewing and analyzing the defamation claim in connection with your motion for summary judgment.
Oh, absolutely.
Okay, so Mr. Richardson's defamation claim was so frivolous that it warranted a $100 offer of judgment, but it took you tens or 20s or 30s of hours over a year period to address.
What was addressed was the fact that I did not want the client to have the expense of a jury trial on the defamation claim, knowing how expensive that is. So yes, there's a lot of time spent on the summary judgment. And, there are, nuances that are different in a motion to dismiss than in a summary judgment research, that you're going to direct it toward. So, yeah, I thankfully so, or, I spent a lot of time on the summary judgment, or so I feel.
Okay, based on the documents that have been presented to the court, the substantial, if not overwhelming amount of time that you spent analyzing the research claim came after the expiration of the 9/11/68 offer.
I don't think so. There was a lot of research done on the motion to dismiss on the defamation.
But I'm
And
asking,
even prior to that, you can see the research that was done in our frivolous litigation letter to Mr. Downs.
that letter which you showed were 3 short paragraphs basically saying this is opinion. That took 20 minutes to write, correct?
No, it probably took longer than that to write. And then you got the research behind it. And then the motion to dismiss spent a lot more than 3 paragraphs on the defamation claim. So I'm not quite sure what your point is. I mean, if
Don't
you
worry about his
want-
point. Just answer his questions.
And my question again was, based on the documents presented today to the court, the affidavits that we just looked at, the vast majority of time spent analyzing and responding to Mr. Richardson's defamation claim came after the expiration of the 9/11/68 offer.
Based on the 2 affidavits in evidence, really the only time for the defamation should be in the second affidavit after the offer of judgment statute. That's the only place it belongs. It doesn't belong in the first affidavit.
Now, you brought up Rich Capriola, and I had that in my notes too. Rich Capriola has been practicing for 30 years, correct?
Yeah, he made right around there, give or take.
He's a very experienced attorney.
Yeah, I respect him a lot.
Okay. And he's billed some time to this case too, right?
Yes, that's correct.
And so do I hear you saying again that Mr. Richardson's claim was so frivolous that you needed to bring in basically 60 years of legal experience to help you combat it?
Well, don't we ought to add Lindsay's time to that if that's the way you're viewing it? But no, my point is I chose to work at a law firm with a dozen plus attorneys for a reason, right? I like the sounding off and the bouncing off of ideas. And so, yes, Mr. Capriola has some time on this case.
And you believe that, no, strike that. You would agree with me, just looking at your 9/11/68 affidavit and the invoices attached, once again, we see numerous instances of block billing, where you're doing all sorts of tasks in one time entry.
Okay, so if your definition of a block billing is that there's more than one task contained in it, I will tell you the longer entries probably have that.
Okay. And so it would be impossible for the court or you or I to determine the specific amount of time and the reasonableness of that amount of time on any one particular task.
Well, in this case.
Send
on
us
the
to an
9
example, Mr. Johnson. It was helpful to see an example in the 9/15/14. So what's one that is
Sure, let me-
troubling you in the 9/11/68?
Let me pull up. Pull up a good one.
Because I saw a couple, but they were for 20 minutes and I'm
Yeah,
not-
there are, and that's fair. Like, we'll look at the first page of Exhibit A, October 11, 2016. Review email from opposing counsel, research argument supporting basis for discovery of reputation, draft outline for motion for summary judgment, research specific examples of categories of defamation per se.
Right.
And it's not clear to me that all of those relate to the defamation claim at issue. Only one specific line references it, but there's 2 hours of time and we can't divvy that up.
No, that all relates to the defamation claim. I mean, yeah, I mean, that all relates to it. That one, I don't see a reason why you'd want to even allocate it. I mean, it's kind of like the next entry right after that, research case law for inclusion of summary judgment. Then there's a separate research for Mr. Richardson character. I mean, that character is on his, character evidence of reputation, if we have to go that far. So those both, even though you call that a block billing, those are both for defamation.
Okay. Let me move on. Let's look at your time entry, and I'm on the statement of account that you sent, or that contains your time for the association. On December 20th, 2016, you billed the association for attendance at Jack Richardson's deposition 6.5 hours. Do you see that?
Correct.
Okay. And then if you go to Exhibit B, which is what you billed the insurance company for, there's a time entry that same date, research for procedure for moving for mental evaluation and gun laws, attend deposition of Jack Richardson, 6.6.
Well, hang on a second, but who's the person? I'm trying to get to that entry. Just a second. I believe the person on that one's Lindsay.
Okay, you're right. Point well taken.
Okay. Yeah, I believe I understand, Mr. Johnson. This does get confusing when I've got two different clients and two different rates.
You don't have any engagement agreement with the insurance company about the rates that you'll bill for in connection with,
Ooh,
what's that?
I would just said, ooh, I'm not 100% sure one way or the other. I will be honest, and I apologize. When you asked for retainer things, I was only thinking of the association. I don't know if I do or not with this insurance company. I will tell you, I don't have any, I'm not a, what do you call it for insurance companies like Mr. Barr is, where you're what do you call yourself, Mr. Barr?
Panel counsel?
Panel counsel, that's right. I'm not a panel counsel with any insurance company. This was due to a conflict with their panel counsel that I got the representation on the insurance end. So I don't know, there just would have maybe just been an email back and forth, or there could have been something, and I apologize on that, Mr. Johnson.
And the work that you did for the insurance company was just for defendant, which defendant was it?
Marshall.
Okay. All right, final topic, and I'll move on.
And it was just Marshall on the defamation too.
I understood. I'm going to show you a document that you've given to us. Do you recognize this document?
Yes, that's a list. There probably should be two of those lists where we got payment on our invoices from the association.
I'll represent to you that we asked for all documents showing payment of your invoices in this case, and this is what we got, a single sheet of paper.
That's not a two-page document?
No, sir.
Okay. The reason why I say there should have been 2 pages, and I'll go back and look, and I maybe flip it to you right now, is because I think I can, yeah, you can see at the top here, this is matter 11 for Jack Richardson. There should have been one for, I think it's matter 9, which was Jack Richardson Insurance Defense.
I don't think we got that.
I apologize.
In any
I kind
event,
of distinctly remember doing that recently here, but I'm sorry.
and this is a document that was generated by your firm,
I actually generated it.
and this constitutes a record that shows payments received in this particular matter.
Correct. On the
And this is something you keep in the normal course of business?
Yes, I have no, this is, should be an accurate record of the payments received in just the Jack Richardson Roman numeral 2 matter, Your Honor, which is the ones that support the affidavit for the 270 hours, $270 rate.
Your Honor, I'd move this into evidence as Defense Exhibit 1 or Plaintiff's Exhibit 1.
Okay, any objection, Mr. Pastel?
No, Your Honor.
Mr. Barr?
No, sir.
Okay, it's admitted.
Mr. Pastel, I think you'd agree with me. There is no way to look at this document and then to look at the statements of account attached to your affidavits and to determine from these 2 documents exactly what the association paid on those statements of account.
No, you can't. But as I testified, we don't have, we billed everything. We were paid. We don't have an accounts receivable with the Phoenix, except for kind of what I'm doing this month, and probably last month's bill hasn't been paid.
Okay, so there's no accounts receivable. You would agree with me that to the extent Mr. Richardson is obligated to pay attorney's fees, he's only obligated to pay what the association paid you and what the insurance company paid you, correct?
Correct.
But we can't tell from looking at this document what was paid on the statements of account that you've presented to the court.
But it's overall a bigger number, so tell me what your concern is.
Well, I can't look at the statement of account. It's not broken down by month. It's not broken down into what the client was asked to actually pay, and then match it with this that's just a random string of things. Some of them say payment of April, May, and June invoices. Some say payment with a bunch of numbers. Some are payments that clearly come after anything in dispute in this case, which must be normal HOA assessment type work. But if I or you wanted to figure out what the association paid, there is no evidence other than Mr. Pastel's oral testimony as to what was paid.
Well,
But if this, I guess I'm understanding it a little bit differently. If the Phoenix pays on a routine basis some money to Mr. Pastel's firm for HOA matters, that wouldn't appear here because there's a filter applied. The dollar amounts here are paid by their client only in connection with the Jack Richardson Roman numeral 2 case, which is the lawsuit that Mr. Downs brought on Mr. Richardson's behalf, alleging defamation, et cetera. So I'm not disagreeing entirely with you, Mr. Johnson. This doesn't really help us understand for what specifically the client was paying, but based on Mr. Pastel's testimony, which I don't think you've impeached with your line of questioning, these figures are limited to invoices for service in connection with what we'll call the Richardson lawsuit. And the total number, I'm not doing all the math, but is real clear just looking at the first 10 entries, exceeds the amount that Mr. Pastel is trying to collect. So part of me says, do I really care? What was the $1.50 for on Halloween? I don't know. And I know you're not fussing about the $1.50, but it really doesn't matter, because if you were to tote all those up, it's going to be a lot more than Mr. Pastel is asking for. So if he did get you more granularity, which I may tell him he needs to do based on how we wrap up in a little bit for what sounds like will be part 1 of our hearing, we may need to get you more. How's that going to change things for what Mr. Downs is trying to do here?
My only point is, if there's a finding that under 9/11/68, Mr. Richardson's liable for fees, he is liable for fees that have actually been advanced by the association and their insurance company to Mr. Pastel's firm. And other than Mr. Pastel's testimony that everything's been paid, I don't think you get there from this document. But
Okay.
Judge, I understand your point. I'll move on.
So, but before you move on, in your experience, what do you see beyond something like this? This is not particularly helpful. I trust Mr. Pastel that it means what it says, but what would you, Mr. Johnson, typically see when your opponent in the litigation is trying to prove up, here's what the client paid?
Something closer to what Mr. Barr has done, which is he's got a summary of all line items, but then he has the actual monthly invoices. And if he says at that point, the client, here are the invoices that actually went out to the client on a monthly basis, and they paid these, that's probably good enough for me. But here we've got, with respect to Mr. Pastel's invoices, there are no invoices. There's a statement that he's generated that doesn't break anything out. We don't see what the client got and paid from. We have testimony that they paid something, and here's a bunch of time entries, but there's nothing connecting them together.
Okay. Let me, so I have pulled up now Mr. Barr's affidavit, and it does look very different. So what you're referring to is not the big spreadsheet. That's basically his bills, their internal records, his version of Orion. Is it Orion? Is that what you called it, Mr. Pastel?
I use Orion. Matt probably uses a different.
No, I know, but it's Mr. Barr's version of Orion. So it's Exhibit B of Mr. Barr's affidavit that you're talking about, Mr. Johnson. That's what you normally see, a series of letters or invoices to, in this case, Arch Insurance Group, detailing what was involved and the size of the bill.
That's correct. And what he's got are similar to what my invoices look like and everybody else's. You can tell from them that month's billing, but you can also see where the previous month's invoices have been paid and what the current balance is. So I can look at these and tell that he was paid for his work.
It's a different software, but I'll put it this way to you. Had I just had one client and everything for the month that was billed was acceptable, you know what I mean? I didn't have to culminate stuff out, then mine probably would have looked darn close to this because I would have just printed out the actual invoices sent to the client for this matter, right? And then you would have seen it matched up to the dollar amounts over there. But in this case, I'm at a disadvantage for Mr. Barr because I could either done this and blocked out things and then add them by hand with math and that kind of stuff. But I'm able to download the statement of account on Excel, right? So it'll do the summation and totals for me and that kind of stuff. And I think we're just talking semantics and looks of the difference of it. You did not ask for a copy of our actual invoices to the client, which and I don't have any reason to hide now that the case is over. You know? So
Okay.
I want to get off point. We did, and your response was, we don't send invoices to the client. We do everything electronically, which didn't really seem to make a lot of sense, but I understand what you're saying.
Okay. So I want to pause us for a second. It is, depending on which clock you look at, either way, it's just a few minutes to 4. My time is constrained. Everyone's is, but I'm going to need to roll off in a little bit. We're not done, and I'm not rushing anyone. Mr. Johnson, I want you to be able to finish your examination of Mr. Pastel. That may be a natural break point. How much more time do you want to question Mr. Pastel?
No, Your Honor, I think I'm done.
So are there things, since we're not going to finish today, are there things that would be helpful to you, Mr. Johnson or Mr. Downs, that Mr. Pastel could get you? Because I think we have sort of the electronic/print divide going here. It may well be that the invoices to the Phoenix go electronically, but I bet you dollars to donuts that the person who pays the bills for the homeowners association can press print and would get a paper version of a bill so that it could go into a file. I'm not interested in killing trees, but it may be that there are some things Mr. Pastel could get to Mr. Johnson and Mr. Downs between now and when we next convene that would clear some of this up. And I'm not, Mr. Johnson, trying to undercut your argument, because now Mr. Pastel can get you something and you'll say, Judge, but I had a winning argument until he gave me those records. I just want the reality of it. And I don't want you, Mr. Johnson, hampered because all you got was that one pager that is particularly unhelpful. But I want to give Mr. Pastel a chance to push out ultimately into the record that which would make clear, here's what I billed the client. Because it puts me at a disadvantage in the end if I decide that there is some amount that Mr. Richardson owes. It ought not to be more than the homeowners association paid in connection with those particular line items. And it sounds like it should match up for the most part with the bill to amounts in the affidavits that Mr. Pastel provided, but we lack the actual invoice that was sent out. And that may be a fair task to assign Mr. Pastel between now and when we next meet. Is that something you'd want, Mr. Johnson, or you would prefer to rest on that murky one-page document?
No, I would. Here's my overarching issue. I believe the evidence shows that the HOA did not do any substantive analysis of Mr. Richardson's defamation claim until after it made the 9/11/68 offer and after it was rejected. And our argument will be that there is some gamesmanship, that they held off. They just wanted to throw an offer out there to basically give them prevailing party attorney's fees, which is not the basis of the statute. But my argument is that they didn't do any substantive work really analyzing that claim until after the deadline had already expired. Mr. Pastel now says that, no, that's not the case because he's cut out time entries from earlier that would show that they did the substantive analysis before. They're just not in the invoices presented. So I'd like to see the actual invoices that the client received with all time entries and evidence of the payment on those invoices.
So Mr. Pastel may be getting you invoices that are more detailed, let me put it differently, have some entries that you don't see in his affidavits, but you're not going to, when we reconvene, box him about the ears about that, because Mr. Pastel has made clear, look, I am not representing that the 9/11/16 invoices are, I guess it would be the 9/15/14. The 9/15/14 invoices, that's not everything we did for the client, because if we did work on defamation, we didn't win that in the dismissal. And so you may see an invoice from May of whatever year we're on, 2016, that's going to look bigger and have more entries than what's in Mr. Pastel's 9/15/14 affidavit for the very reason he gave. And that would undercut your claim, Mr. Johnson, but your claim right now is based on the records you have. And that's the only claim you can make. Otherwise, you're having to speculate. But if Mr. Pastel's contention is correct, you are going to find some entries and invoices that don't align with the billing records in the 9/15/14 affidavit. And ultimately, if I'm understanding everyone, that should not be a cause for alarm, because that would represent Mr. Pastel dutifully culling out, well, defamation research, if he did it, pre-ruling on the motion to dismiss. That's not 9/15/14 material. I ought not to seek to claim that. If there's nothing there, then Mr. Johnson, your argument, which I picked up on, remains consistent, that the bulk of the defamation research is after the offer of settlement expired, and that paints a slightly different picture. So I think I get that. Was there more you wanted to add, Mr. Johnson?
I just got two housekeeping. I want to put into evidence two statements that Mr. Pastel provided to us that show work prior to the 9/11/68 offer expiration. And I can put those in very quickly.
Okay.
And no objection, Your Honor. In fact, they'll be reproduced again, sort of, when I do the invoices and the payment reconciliation.
So what is this? This looks like,
They asked for time entry between, I think, what, July 1st and August 31st or something like that.
Correct.
okay.
And just so you know, that you maybe have figured this out, our contention is that they did not do any substantive research on the defamation claim before or while the 9/11/68 offer was pending, and these invoices tend to show that, so I'm putting them in for that purpose.
Okay, and the before is the pretty important part. So I don't want to make Mr. Pastel reinvent the wheel. What you're sharing right now, Mr. Johnson, and I will admit Mr. Pastel doesn't object, is this not what you want Mr. Pastel to now produce? It seems like he gave it to you. This is not his affidavit. This hasn't been culled. If are these all the billings under this account?
No, this doesn't go, this starts when I made the offer and stops after the offer expired, which is normally 30 days, but I think in this case, we had it more like 45 days under agreement.
Okay, so this is a narrower time frame than the period of litigation.
But I
Yes, Your Honor.
think if I understand what I'm going to produce is the actual monthly invoices, which will have all the entries, the payment ledger, and then hopefully it may be screenshot, but of the reconciliation of payment to invoice.
Okay, those would all be good. Mr. Johnson, was there something else you said you wanted to tender two things?
Yeah, there's one. This is for this time period we're talking about, after offer made, while it's pending. This is the exhibit you have in front of you is the time entries that he billed to the association. The other document is a related statement that is the time entries billed to the insurance company.
Okay, for the same time frame of mid-July through whenever it looks like end of August.
Yes, sir.
Okay. All right, those are both admitted. But it sounds like, Mr. Pastel, you will be providing to Mr. Johnson and Mr. Downs similar looking documents that go further back in time. So we will be able to address Well, what kind of defamation
Well,
research were you
It
doing?
it won't quite be similar because I'm going to do the actual invoices. So what we saw streamlines an invoice. Invoice will have a cover page, that kind of stuff. So
Sure.
it'll be a lot more soft paper because I'm going to produce them as PDFs.
Okay. Is there anything, Mr. Johnson, you were hoping to get from Mr. Barr that you didn't in preparation for this hearing, so that when we resume, if you plan on cross-examining Mr. Barr, we don't need to say, well, now we need a third round, because really that ought to have been shared as well.
No, I'm satisfied with Mr. Barr's production. It looks like what I would have expected, and my questions for him will be much, much shorter.
Okay. And Mr.
Okay,
Downs, not shortchanging you, was there anything you needed, or Mr. Johnson speaks for your team on this issue?
That's right. Nothing other than what he's already said, Judge.
Okay. All right. So Mr. Pastel, we're going to pause here. How much time do you need to generate those records and make them available? You should get them to Mr. Barr as well. Not that he's going to ask you questions about them, but let's get them to everyone. How long will it take you to get them out?
Actually, hopefully not long. I mean, could almost do it during a break, but I know we don't want to, and he's got to analyze them. But that's the nice part about the software.
Okay. So it sounds like then what we should focus on is when, and I'll delegate this to Ms. Niles, who had to leave this format, but is listening in and watching on YouTube. She can coordinate with you all as to when we'll resume this hearing, but as long as it's not in the next 20 minutes, which it won't be, you'll be able to get these materials to the other lawyers. They'll have an opportunity to digest it, so that Mr. Johnson will be razor sharp yet again with his thoughts and concerns about whatever it is you supplied.
Okay.
Okay. One last housekeeping thing from my end. Zoom is fine with me, and we can continue to do it this way. The courthouse it was never closed. It was always open for urgent business, but more and more people are coming into the courthouse. I don't require that, but I want to make it clear that that's an option for any one of you. You're welcome to stay where you are and do this remotely. The technology works, and as long as Ms. Kell tells us it was doable for her, we can keep it this way. But you should know that if any of you prefers the in-person experience, we can do that. I will add this. It gets more complicated for the poor court reporter if it's hybrid. So if you know that a couple of you are going to go remote, I'll probably ask you all to go remotely. I've had a few where some lawyers are here and some are remote, and we have to turn speakers off so that we don't get feedback. And it's doable, but we're not at a place yet where it's appropriate to require everyone to be here, and I don't intend to do that. Okay?
Thank you. I
Mr.
appreciate
Barr,
that,
anything else at this point for your very quiet client?
No, Your Honor. I will say for planning purposes that I'm just going to parrot what Marvin said today. I don't have a lot of original argument on the good faith issue. I'll do the same stuff with my affidavit and state what I need to in my place. But I think my presentation will be very short next time.
Mr. Downs, you will be making argument on behalf of your client after we have heard whatever remains of the examination of Mr. Pastel, and then the Barr version of the same, but it sounds like that'll be shorter. What's your guesstimate as to how much time you'll need?
I mean, not nearly as long as the opening, Judge. I mean, I would say, 30 minutes at most.
Okay.
Probably less than that.
We'll try to block out more than an hour. I just wasn't sure how long this would take, and I hadn't done an attorney's fees dispute in a while, and it quickly came back to me once I was looking at the billing sheets. These are not short hearings, but they take the time they need to take. So I'm not fussing. I would just soon not have to drag you guys back a third time, as wonderful it is to see you again. So we'll aim to build in hour and a half, 2 hour block, no requirement to fill it. Ms. Niles will be in touch with you all. And Mark, you're free to join in the future. I'll make sure you get notice of it as well through Mr. Pastel. It's an open public proceeding, and you dialing in via Zoom was fine. It will also be that YouTube feed, should there be other members of the board who, or any of the clients of these folks who want to be able to watch and listen to what's happening.
And now our families get to see us too, right, Judge?
That's right. That's
You can
right. My
watch-
kids don't watch this YouTube channel. If it involved Fortnite, they'd watch it. But they do not really care for my channel. Every once in a while, my older son will look at it and say, Dad, it is so boring. He said, no, this is important stuff for a lot of people. But because we don't have the weaponry of Fortnite, he loses interest real quickly.
I would love to see your Fortnite game, Judge.
Yeah, that is not mine. Ms. Kell, you'll be taken care of by these fine lawyers, I am sure. And it probably would make sense to have Ms. Kell join us for part 2, but I leave that to you all to arrange. And Ms. Niles will be in touch soon, okay?
I just have a
Thanks, Judge.
question. I understand that everybody's splitting the cost of this transcription, but do you all want it transcribed, this first part, or do you want to wait till the second part and then decide if you want the whole transcript transcribed or not?
My preference would be to wait until it's all done.
Sounds good. All
That's
right.
fine.
Yeah, hopefully we'll reconvene soon enough that we won't have forgotten everything.
We will.
And-
No, no one has I don't have a vacation, so it'll be soon.
Judge, I think Ms. Niles has my email address from a prior hearing that we did several weeks ago. So do you want me just to contact her for the audio?
That'd be great. Please do that.
Will do.
All right. Thank you, everyone. Be safe.
Thank you.